All right, welcome everybody to Exploring Racism in America, the first on this series with Russ Lovell and David Walker. Today's presentation is, as you see in front of you, Des Moines Unbiased Policing Ordinance and the NAACP Anti-Racial and Profiling Bill. Thank you for joining us today, and thank you to Maura Strasberg for putting this series together for Drake Law School. Okay, take it away, David and Russ.
Hi, welcome. I'm Professor Russ Lovell, Emeritus, a longtime on the faculty at Drake and co-chair of the Iowa, Nebraska, and Des Moines NAACP Legal Redress Committee. My colleague, David Walker, who are you?
I'm a longtime faculty member and like yourself, Dean, at the law school and co-chair of those legal redress committees with you. And we're pleased to be able to speak with you today about really topical and very important issues confronting our country and certainly Iowa and each one of us. Thank you.
We're delighted that the law school is sponsoring this racial justice series, and we're pleased to be able to kick it off. It certainly seemed to be a timely topic. Race and criminal justice have been on the agenda for at least a decade for civil rights advocates like us and the NAACP. But certainly it could not be more topical than the issues of racial profiling, police brutality, pretextual stops that are a part of what we'll be talking about today and are why so many people are in the streets at this time. Certainly the George Floyd murder is some described as lynching by knee, has been a real focal point for kind of bringing out the pent up, I think, anxiety and anger in dealing with these issues, particularly by the Black community, but so many other allies that likewise could see the kind of the disdain, kind of that the officer had, that a sense that he could do that almost with impunity. But we've certainly the deaths of Breonna Taylor, Ahmaud Arbery, the paralyzation of Joseph Blake, and even the Central Park incident involving Amy Johnson are, I think, part of the catalyst for why these issues are getting such attention right now. It occurred to me that we have a slide that talks a little bit about some of the history that led up to the Des Moines Ordinance, and it seemed like that maybe was a better place to start than where I had put it. And so this will give you a little bit of background in terms of some of the ways that this issue has been worked on for the past 10 years, particularly here in Iowa. And then our plan would be to talk about the injury, the harm that racial profiling and pretextual stops cause, and then a little bit of the evidence here in Iowa as to the extent of the problem here, and then we would focus on the first major legislation in Iowa that has addressed these problems here in the Unbiased Policing Ordinance that the city of Des Moines enacted on June 22nd of this year. The national NAACP had a groundbreaking report, the Born Suspect Report, 6 years ago in 2014, that made this a top issue with regard to the NAACP's civil rights advocacy, and certainly it's influenced our thinking, and it provided a draft or model set of laws that we used as a starting place with regard to the legislative work that we've been doing here in Iowa. David, you want to talk a little bit about some of that?
Sure. And it really goes back even before the NAACP's publication of Born Suspect in 2015. We collaborated with Amos in a fact-finding following reports to us by parents and young people of stops that were inexplicable other than the common incidents of race running through the stops. And so in 2011, 2012, we collaborated with Amos and began looking into these matters, eventually forming alliances, and then with Russ and me largely drafting for Iowa a statute that we did submit that did, you'll see, passed through the Judiciary Committee, but did not receive a floor vote, and it stalled in the 2019 session of the legislature. As you think about this, important issues that we've had to address are simply the definitions. What is racial profiling? When is a stop that is based on a violation of some traffic law pretextual? How do you establish the motive? Must it be the sole motive, as in some state racial profiling statutes? Is it sufficient if it's a motivating factor? Or candidly, when should race ever play a part in a traffic stop? And it's not just traffic. These are also pedestrian stops, stop and frisk. And particularly during this last 6 months, we've seen a rise in the frequency of use of bicycles. These are bicycle stops as well. When should race play any part in one of those stops? Well, how do you prove that? One of the ways that is helpful is to look at the data. And so another aspect of these, the legislation, the ordinance, and our efforts in Des Moines has been data collection. And what you'll see, I think, is that as we've heard and are told and can honestly believe that probably almost all law enforcement people are ethical, principled, abide by the law, and do not exhibit racism, but there's a percentage when it's clearly true. And some of the data collection that we'll allude to and cite to suggests that this would be useful in identifying individuals. So we've had about a 10-year history of this. It's not done. Russ, I'd like to go back to the second and third slides, and maybe that's a place to begin. The NAACP's mission, of course, is to prevent and end racial discrimination, to work to secure civil and political rights for all people, regardless of color. And we began seeing a need to pursue a number of strategies. Some litigation, you'll see a number of sites. Russ and I co-authored 5 amicus briefs. We've been involved in remand litigation, soon to be an appeal in Waterloo. We currently have an amicus brief due within the next 5 days, and draft for which. But it seemed to us that a legislation was a kind of a take note. Everybody's be on notice that racial profiling is prohibited, that pretextual stops that are discriminatory are prohibited and a violation and a basis, if not for damages, in a particular case, at least for discipline. So we've pursued quite a bit of litigation and legislative activity. And one of the reasons for that was the widespread incidences of racial profiling that you would read about. Walking While Black, it's a shocking incidence of stops, arrests for jaywalking that occurs for Black and African American persons compared to white persons. Studies in California, Florida, and Illinois demonstrate that shopping while Black is distressingly a cliche. We've dealt with incidences of that. We particularly heard from mothers alarmed at their children being stopped on the way to a prom, dressed up in a clean car, because the color of their car happened to match something reportedly or other reasons given. But one of the aspects of white privilege is that however inconvenient a traffic stop for a ticket may be for white people like Russ, me, any of you perhaps, it isn't fraught with the risk of danger and demonstration of tragic incidences that our history and current events reveal. So we began to take up this issue in earnest 10 years ago and followed it. Russ, why don't you take it back?
I think that we need to make very clear that this is an example where both grassroots advocacy as well as advocacy by lawyers and persons trained in the law have a really important collaboration. And so on that original slide, White also mentioned the annual summits on justice and disparities that our colleague Betty Andrews, who's the president of the Iowa NAACP, has put together over the last at least 8 or 9 years, I think at least back to 2012. And I think to her great credit, she's almost single-handedly put these issues of race and criminal justice on the agenda here in Iowa. And so we've worked really closely with her. She was clearly the lead negotiator on the Des Moines Unbiased Policing Ordinance that we did so much research and drafting and collaboration with her. But clearly that grassroots has been important. CCI was important in that kind of effort leading up to the Des Moines Ordinance and other groups as well. So those are all key. I think that let's go back that just a little bit to the slide here. David mentioned that most officers are not racist, but we're also concerned about implicit biases, and we think that that is a factor that can cause individuals to use racial stereotypes. And when you look at the examples here on this page of obviously this is it's not just law enforcement officers that use racial stereotypes. Obviously, across broad segments of our population. The first one up there, James Connolly, is of course a local situation, a young African-American man who was at the Old Navy store in Jordan Creek Mall about 2 years ago, checking out, and all of a sudden he's accused for shoplifting the jacket that he had on. As it turns out, he bought the jacket at Old Navy a month or so earlier. He's a graduate of the University of Northern Iowa. As I recall, he played football up there. He kept his cool, and so he kept insisting that, it occurred to him before they called the West Des Moines police. He said, "You go up and look at your video cameras, and you're going to see that I wore this jacket when I walked in here." And he insisted that they do that. And so finally, grudgingly, they did. And sure enough, they saw that they'd made a huge mistake. But I think that kind of an implicit bias that can affect so many. And so many of these examples on this page are in this kind of calls for service, much like the call from Amy, I think her last name was Johnson, from Central Park, calling the African-American bird watcher and calling the police and claiming that, in fact, she was being attacked by him. And so the good news there was that the police obviously did some screening of that call and vetting of it, and somehow were able to determine that, in fact, they didn't go in with guns pulled and their arms out, and so that avoided a tragedy. But one of the things that we were able to deal with in the Unbiased Policing Ordinance in Des Moines is dealing with that issue of requiring the police to vet and carefully screen out those type of calls for service that may in fact be motivated by either intentional or implicit bias, and that it's really important that the police not allow themselves to be instruments of the discrimination of others. And so that's the slide here that we have here. I think that the next slide, let me take the Paul Butler then back, but Paul Butler is a Georgetown law professor, a former U.S. prosecutor, and he had written a book long before George Floyd called The Chokehold. And the book has been edited in other places. You can find edited versions online, including in The Crisis, which is the NAACP monthly magazine. But Butler is trying to help those of us who are white to better understand what it is to be a person of color, particularly a black male in our society, and this fear, this omnipresent fear that no matter how successful, no matter how innocent, no matter how good you've been, that you could be pulled over and one of these incidents that could lead to injury or even death could occur. And his example was the chokehold. And it was pretty much, the example was much like, it's kind of, he didn't use the knee chokehold that was used in the George Floyd case, but the more traditional one. But it was like you feel that you're in a chokehold from the moment you walk out of your apartment or out of your home, because you never know when it's going to be ratcheted up, and it could be ratcheted up in almost an instant, and your life could be very much at risk. And it's a powerful example of, for those of us that haven't experienced this. I know that among my white friends, they said, "Well, we've all been stopped. I mean, yeah, we're anxious and we're a little nervous about that, but we don't make a federal case out of it." But none of my white friends have ever been pulled out of the car. None of them have ever been handcuffed. None of them have ever had a frisk that actually goes over their genitals and over all kinds of intimate parts of your body. None of them have been forced to allow a search of their car, or pressured like that, or the other things that can occur in one of these traffic stops. And so those are things I think to keep in mind as we try to walk in the shoes of persons of color that have experienced this. David, do you want to take over some of these other examples here?
Sure. In examining the slide, one of the facts about Iowa that struck us early on, it's generally known now, and one time Iowa led the nation. African Americans and blacks are 3 to 3.5%. I think the latest Iowa Commission on African Americans indicates 4%. But it's a very small percentage of the Iowa population, but 6 or more times that of Iowa's incarcerated population. Then look at the next side. They're 10 times more likely to be arrested for a crime than persons of all other races. And then, in different but related work that Russ and I have been doing, drawing on others, social science researches, we've been struck by the consequence of an African American or a black defendant confronting an all-white jury, as is likely in Iowa with a 96% white population, as opposed to a white defendant. The importance that we're seeing in the social science research is having a jury pool that is drawn from a fair cross-section of the community, and thus is more likely to produce a trial jury that is racially mixed. Racially mixed juries and all white juries convict black defendants and white defendants at about the same rate. I'm going to correct that. They convict white defendants at about the same rate. But an all white jury will convict a black defendant 81% of the time or more, whereas a racially mixed jury will convict a black defendant 66%, a 16% differential. And so as we look at conviction and incarceration, we have to think about the disparities in arrests, prosecutions, and convictions, and think, as Russ was saying earlier, not only about explicit bias, expressed bias, racism, but the prevalence of implicit bias and the attention that needs to be given to jury management and in jury selection. So I'm going to move on, and you'll be able to access this slide, which is an example of, to our thinking, a clear pretextual stop that occurred in Union Park in Des Moines in the summer of 2018 with 2 young black men driving a loaner, clean, white, newish car because their own was in the shop, who were pulled over for no reason that was given. It's about a 15-minute video that went viral and was eventually the basis for a $75,000 settlement, where the two young black men behaved with extraordinary calm. One of the policemen was asking repeatedly, aggressively, even leading questions, saying that he smelled marijuana, that it was marijuana shake on the car floor. And both the young men were asked to exit the car. They were both handcuffed. They were both full physically searched. The driver was handcuffed and placed in the back seat of the police car. A fairly clear threat of being booked, cited, taken to the station was made. Eventually, there was not even a warning. Fortunately, our colleagues at CCI and the mother, who was a member of the Racial Justice Committee, asked for the video. And it's apparent, and if you look at this, it's very telling. We're not just talking about a traffic stop. There's much more to it that entails humiliation, intimidation, fear, and harm to the community, and harm to the notion of community policing that I think everybody is seeking. Russ, do you have anything more you want to say on this slide?
Well, I think it had over 12 million viewers, and it's a textbook example of the potential for a stop going bad. I mean, the officer is so provocative throughout the entire time. Ultimately, he never gave any reason for the stop, and eventually waved them on without even giving them even a verbal warning. It's so flagrant. But again, if these young men had not been given the talk and been so restrained, it could easily have gone to something really, really bad. So I really encourage you to watch it. The video is absolutely first rate because it is the officer's own body camera. It's not somebody else that's doing it on their cell phone. It's a really top drawer video. We put also some other very important links here. One, I think the law school's own racial injustice link gives you access to many of the materials. But one of the best recent publications that we used it a lot in our negotiations with the city was this Leadership Conference on Civil Rights, New Era on Policing report link there. This is almost a 450-page online book, which is but it's lots of pictures, lots of big print. But what's really exceptional is it is filled with footnotes in every instance in which they make a recommendation with regard to police practices or reform. There is a link to a statute, an ordinance somewhere in America where it's being done. So you can find out what the Minneapolis practices are with regard to stop and frisk. You can find out the New York City or the Seattle or Baltimore and so on. And you can do it at the press, just a click. It's really, really a wonderful, wonderful resource. Further down, we've mentioned the NAACP Born Suspect, which is really still an outstanding resource. One of the relatively few traffic studies that have been done here in Iowa was done by Professor Chris Barnum of the St. Ambrose, a former police officer himself, but now on the faculty there and has been for many years. Iowa City has made that report publicly available, and it's very good. And then just this past week, one of the persons, an ally of ours, Harvey Harrison, working with CCI, has a new website that puts together a good deal of his research and with regard to data with regard to the Des Moines Police Department. You've heard us talk a bit about the pretextual stops and racial profiling. Justice Sonia Sotomayor's dissent just a few years ago tried to get this back on the agenda of the United States Supreme Court, which has pretty much looked the other way on these issues, and talked about it. What David and I are saying, that stops can have severe consequences, much greater than just the inconvenience that's suggested by the name of the word stop. That the officers have an array of ways in which they can probe and examine you, and that one of the concerns about the ability to allow officers to make these pretextual stops with impunity is that it allows at least the rogue officers to target pedestrians or drivers in an arbitrary manner. And we'll talk more about the other parts of her opinion. Whether, again, she's saying, trying to make sure you understand how degrading a stop can be, particularly when the officer is looking for drugs or something more. And that she refers to the Wren case. We'll talk about that a little bit more in detail, which is the U.S. Supreme Court case from 1996 that allows generally pretextual stops, but at the same time qualifies that by saying, but not racially discriminatory pretextual stops. And so we'll talk more about that, but it's been honored in the breach, not in its enforcement, and that's a big part of the new legislation. But that generally speaking, the courts have said if the officer can point to any type of possible infraction, traffic, even a minor one, that's sufficient to allow the stop, even if we think that there was other aspects involved. Again, supposedly, as long as it's not racial.
Yeah, I add, Russ, that these stops are always for people fraught with the risk of physical violence. You see that in cases like the George Floyd, where clearly he was under control, even known to that very officer, was handcuffed. There's no reason for the gruesome conduct of the police. And if you heard Doc Rivers, the coach, speaking recently, he's talking about the fear of Black people, and we have heard this from parents. We've heard this from our own state NAACP president, Betty Andrews. You heard it from Doc Rivers. It is the fear of physical violence, and one African-American woman, former Drake Law School employee, whose children were stopped on the way to the prom, was alarmed, and just more than that, because her son, a all-around good kid, when he was stopped and the police came up, he automatically reached over to the glove compartment to get the registration for the car. And of course, when that kind of police officer too often fears that one is reaching for a gun, or in the Jacob Blake case, that there might be a knife somewhere around, and seen incidences of violence result. So this is an area where attention is needed, and it's not sufficient for it to be an internal policy or there to be periodic education on implicit bias. It needs to be codified. It needs to be rendered into law. So that's been our efforts. And this slide shows some of the many consequences of this behavior. Let's go forward, Russ.
I think before we leave that slide, I think increasingly in this pandemic, the racial disparities with regard to Blacks in the terms of health are becoming apparent. And it's been long the rule that people of color, particularly African Americans, have high blood pressure. There's just, I think, the increasing evidence that this kind of fear of the pretextual stops, racial profiling, builds up bitterness, anger. It affects things like high blood pressure. It affects stress and mental health, exhaustion. It has real consequences, and then you see that pent up anger, flash out at different times, as we're seeing in some of the protests and so forth. Someone asked about whether the police officers track the demographics of individual officers, traffic and pedestrian stops, and the answer right now would be mostly not in Iowa. We'll talk more about that need for that data collection and how it can be used as we get a little further into this presentation. Before, I guess the best traffic studies that have been done in Iowa have been done by Chris Barnum, the professor at St. Ambrose. And so to understand these studies, why it relies on the accuracy of the department's own stop data if they are collecting it. And right now, many are not, but some are collecting some of it, but it isn't largely publicly available. And so Barnum takes that stop data, and then he will compare that by race with regard to the racial percentage of drivers on a specific city street. And he's done this in Davenport, one of the Quad Cities, and also in Iowa City. And so he actually has graduate students that are employed by him as part of these studies, and they'll be out actually monitoring the actual traffic flow on specific streets in Iowa City or Davenport to determine the racial percentage of drivers there. So he's not just making comparisons to the general population of the city, the racial percentage, but actually to the percentage of blacks or Hispanics that are being stopped on that particular street compared to the number of arrests or stops that are made there. One of the other things that his studies do, and this is very good, is that he not only studies the racial disparities of the stops, but also on what he calls the outcomes, the discretionary actions that are taken by officers that occur after the stop, like whether the driver is asked to get out of the vehicle, whether the driver is frisked, whether the driver is handcuffed, whether the driver is asked to consent to the search and to search the vehicle, was there a use of force, and so on. And we'll go to the next slide. His research consistently shows significant racial disparities in the stops by officers of blacks in Iowa City and Davenport, but particularly significant disparities, huge disparities in the outcomes, the treatment of African Americans experienced after the stop. And as the last comment there is, in our judgment, actually, the conclusions that could be drawn are even more damning than he actually draws. But he does an excellent job in identifying these issues and getting the data that's there. And one of the things I think to keep in mind about how good this data is, that with regard to looking at the outcomes, the basis for comparison is not on general population. It's not on the percentage of, say, blacks that are driving. It's based upon the percentage of blacks that you stopped. And compare that to the percentage of whites as to how many were treated, like to ask to consent, to be handcuffed, to be frisked, to have had their searched. And you can see in Iowa City, it was your chances, you're 2.8 times more likely to be arrested if you were black than if you're white as the basis of one of these stops. You were 3.5 times more likely to have your car searched than you would if you were white. And this, as he said, when you looked at actually what did they find in these searches? Did they find drugs or contraband or a gun? So actually, the success rate was much higher for the searches of the white drivers, the non-black drivers. Why? Well, because they were only searching if they really had probable cause. But with the black drivers, they were whether it was because of implicit bias or a rogue officer, they were searching triple the rate that they would of a white driver. Well, David, let's kick it off. Let's go to the Des Moines Ordinance, and this is the product of work that began at the state level, but then became really focused when that state level effort became unsuccessful in 2019. We had some bipartisan support for that effort, and we certainly want to give a kudo to Senator Zahn, the Republican senator, the chair of the Judiciary Committee, who was a sponsor for our anti-racial profiling bill. And while we've talked about statistical evidence, anecdotal stories are important. And Senator Zahn would consistently tell the following anecdotal story. I mean, his son, who's a football player, was a football player on the University of Iowa Hawkeye football team for many years, and befriended a number of the black athletes on that team. And as he got to know them, and as Senator Zahn got to know them through his son, he began to realize how every one of them was afraid of the police, and afraid of being stopped and what might happen. He said, these are 300-pound athletes that are in fantastic shape and so on, but they are scared of what could happen to them in one of these police stops. And so I heard Senator Zahn talk about that in public, probably at least a half a dozen times or more, in such a convincing and passionate way. And that, along with the statistics, the statistics brought those examples to life in terms of his belief that indeed we have a problem here in Iowa that needs to be addressed. David, go ahead.
Let me just interject as we make the transition to this ordinance, which was, in part flows from our earlier legislative efforts that Russ was describing, Senator Zahn, and that passed out the Judiciary Committee. Let me just call your attention to some of the challenges in drafting legislation. One are the definitions. What is racial profile? How do you define it? What is a pretextual stop? Police and the U.S. Supreme Court authority vigorously support the authority of police to stop anyone for a traffic violation. That might mean a light bulb that is out over your license plate. It might mean a flickering brake light. It might be something for which, for say, Sandra Bland in Texas, failure to give sufficient notice of a change of lane. Sandra Bland wanting to get out of the way of the law enforcement officer, and depending on the state, you may have to give 90 feet notice of a change of lane. And right now, that under federal law is constitutional and not illegal. So some stops are clearly discriminatory because they are black people are stopped for those reasons far more frequently than are white people. And all of the consequences that Russ just described in the preceding slide, you have to have the data. And right now in Iowa, there is no data collection regularly going on that tracks all of those incidences of a stop by race, such as Chris Barnum was able to do in Davenport, Iowa City, and I think it was Dubuque. So definitions, a prohibition in the law, just not internal policies, in data collection. Chris Barnum's study showed in Davenport, for example, that it was just three areas, three zip code areas, I believe, or three patrol or enforcement areas where there were disproportionalities or disparities, and they were able to identify the relatively few officers who were making those disparately frequent stops. So part of I think one of the most important aspects of this kind of law reform endeavor, this has been not only to define terms and prohibit racial profiling, but to provide data collection, which can be done. Law enforcement officers have computers in their cars. It's called the track system. It would be fairly simple to fill out yes or no questions on stop, search, arrest, warning, so forth. And then, as you'll see in our legislation, make it palatable to law enforcement, which generally opposed to these efforts, to make exceptions. What is not racial profiling? And so we have made an effort, listening to Police Chief Wingard and others, to define what is not racial profiling, what is permitted law enforcement policy. But to go forward, then someone just asked the question about accountability. That is essential, and we'll deal with that. Our ordinance in Des Moines provides for the Human Rights Commission to educate the population and to assist those with the complaint in drafting the complaint and filing it with the Iowa Civil Rights Commission. But we'll get to that more later. You can go back to you, Russ.
Abby asked a question: how much has racial profiling bans and requiring officers to live in the community help with policing? We think that a ban on racial profiling can make a big difference. And indeed, we think even a ban on racially discriminatory pretextual stops, as difficult as it is to prove that, will make a real difference on the ground. I know that some of you are just beginning your law school career, but you've certainly heard of Brown versus Board of Education, the landmark decision that held racial segregation in the public schools was unconstitutional way back in 1954. But that decision, even though it was a unanimous decision of the U.S. Supreme Court, had made very little progress on the ground in terms of actual integration of public schools for over 10 years. It wasn't until the 1964 Civil Rights Act was passed by Congress that Congress finally embraced that court decision, and our president, then Lyndon Johnson, signed it, and he embraced it as well. And so, and then we began to see real integration take place. And so, codification of the principle can make a huge difference, and we think that's true. And we fought for that, and we secured that in the Des Moines ordinance. With regard to living in the community, well, that's an issue that we're hoping to work with the city of Des Moines on in the legislature, because at the present time, 80% of Des Moines police officers do not live in the city of Des Moines. For that matter, 77% of Des Moines firefighters do not live in Des Moines. And that is, we talk about a commitment to community policing. Well, the NAACP and we believe that community policing begins by living in the community, to being a stakeholder in its success, to pay taxes, to be involved in it. Not the police chief often says we don't want to look like an occupying force. Well, that's good, but living in the city would diminish that perspective. Right now, there's an Iowa Code statute 400.17 that actually prohibits any city in Iowa from requiring officers to live in the city as a condition of their employment. We think that's wrong, and that's one of the last slides actually in this presentation, that should be changed so that at least cities have that option to have that as a policy choice, and we can have a debate on whether that should be enacted. But right now, we don't have that chance for that policy choice in Des Moines or any other city here in Iowa. Let me see. Let's go back then to the ordinance. The Des Moines ordinance, when we first began to negotiate on it, we were negotiating as an anti-racial profiling ordinance, and it is that. But as we got into it, the opportunity to make it an even broader ban on bias policing was there, and so we took that opportunity. And so this law is indeed captioned an unbiased policing law that mandates bias-free performance in every aspect of policing and service delivery by Des Moines officers and their civilian employees. And you know, it's a big operation. They have something like 450 officers and I think about 100 civilian employees. This, for example, the individual who sends the dispatch out to an officer from a call for service to go to check out Central Park as to whether that black bird watcher is really there innocently. I mean, that's a civilian employee. And so this law covers them as well. And so it bars discrimination by officers and employees, not only on race and ethnicity, but on all of the various characteristics that are listed in the Des Moines Human Rights Ordinance. Certainly sexual orientation and so on are all protected classes there. And it bars discrimination not only in law enforcement, but in the delivery of police services. So it goes far beyond traffic stops to everything that the department does.
Let me
Go ahead.
Russ, let me just underscore a couple of points that Russ has made. One is the importance of having this as a law, an ordinance in a city. And we believe and are advocating to Governor's current Criminal Justice Reform Committee, called the Focus Committee, that it be made into law. Having it as a positive law statement, it registers with law enforcement. So also does the collection of data. We were participating in a subcommittee of the governor's. It's called a committee. It's designed to address racial profiling and with seeing what, if any, legislation is possible at a state level. And in this subcommittee, I'm not going to name the individual, but he's the chief of police for a fairly large suburb, said that once you prohibit pretextual stops that are discriminatory and you collect data, police, and you provide for complaints that are actionable before the Civil Rights Commission, police are going to stop and slow down in their enforcement of the law. He said, you know, if there's no stop, there's not going to be a complaint, and that was that police chief's thinking would be the impact of legislation or an ordinance, you know, like this. We that notion, and I think Russ, who's from Nebraska originally, can speak to this better, but Nebraska passed an anti-racial profiling statute about 20 years ago, I believe. Russ will correct me. It was
2001.
a bare bones statute that prohibited racial profiling and pretextual stops where it was the stop was based on the color of the driver, and it looked like it was solely based on the color. Nebraska at that time led the nation in racial traffic stops. Am I correct in that? And I forgot how it was defined. But 10 years later, following the enactment of this legislation in Nebraska, Nebraska cut that percentage in half, and was no longer number one, but it was somewhere around the median. Cut it from like 12 to 4%, didn't it, Russ?
Right. It was based upon the FBI statistics dealing with marijuana possession arrests, and the ACLU has utilized that data and has come out with reports in 2003 and 2013, then another one just last year. And in 2003, Nebraska was the worst in the nation. That if you were African American, you were 8.4 times more likely to be arrested for marijuana possession than if you were white. But 10 years later, you know, after they had enacted an anti-racial profiling law, they had dropped from 8.5 down to about 4. Now 4 isn't where we want them to be, but it was a huge cut, and it certainly reflected large progress just by the fact that they had the prohibition, and that people knew that the data was being collected that could be the basis for discipline or even discharge if it established a racial profiling.
Or damages. So the simple points are: law makes a difference. Law makes a difference. Data collection is essential to accountability, and accountability is needed. Someone asked a question: is there, under the Des Moines ordinance recently enacted, is there a civil action authorized? There is not. Instead, the remedy is for, with the assistance of the Civil and Human Rights Commission, filing a complaint with the Iowa Civil Rights Commission. Racial profiling is an unfair and discriminatory practice, actionable under the Iowa Civil Rights Act, and one who files a complaint can request a letter to sue, right to sue letter, and pursue remedies fully in federal or state court. Russ, I want to go back to the ordinance because I want to credit Russ in the conversion of this from a merely anti-racial profiling ordinance to one that commands unbiased policing in all aspects of law enforcement, from traffic to the delivery of services. Russ was our principal draftsman. Everybody gets hands on this stuff as it's going forward, but Russ did a formidable and terrific job in converting what was an internal policy into an ordinance that would claim support. So Russ, you go ahead.
One of the things that was helped, well, one of the spin-off benefits of going to that broader unbiased policing was that it allowed us to deal with these biased service calls, like the Central Park incident. And so we got a specific provision in the act, and I think there's very few of these anywhere in the country, that, because I know initially law enforcement said, hey, you can't hold us. We have no responsibility for calls for service. If somebody calls, we've got to go. But again, looking at that leadership conference on New Era Policing report, I said, no, not so fast. I mean, the police can't allow themselves to be the instruments of others' discrimination or bias. They've got an obligation to do their best. They certainly can't just take it on without any examination. And so the standard says that Des Moines employees, if they know or reasonably should have known that the call was motivated by bias, then hey, they shouldn't do that, or they've got to vet that carefully. So I think that it was apparent that the New York Police Department's dispatchers must have vetted that call from Central Park carefully. They're mandated to do that here in Des Moines as well now under 86-44. The only exception in Des Moines police officers' work in which race, for example, can be considered is where they are following a specific suspect description-based identification. Or if they were dealing with a victim, then it'd be a specific subject description-based identification. Otherwise, race and these other prohibited characteristics cannot be part of their decision-making. Eventually, when they become obligated to do data collection, obviously to do data collection, you've got to take race into account and monitor that. So that'll be a change. But one of the things that we negotiated for eventually, it was clear that it was impossible to negotiate for some type of a liability standard that, for example, would take away qualified immunity. That's going to have to be done at the Congress or at the federal level. So we negotiated very vigorously for a very strict discrimination standard, one where if race was a motivating factor, not a substantial or a significant, if it was a motivating factor, then that would be a violation of this act. And so we'll talk about the case of Babb versus Wilkie that came down from the U.S. Supreme Court during the course of our negotiations back in early April. Let's see here. We can maybe, it's in here somewhere. And this case was it was a civil rights case, but it was involving the Age Discrimination Act. And what it made clear was that an entity, a company, or in this instance, it could be a police department, you could have two different standards for discrimination. Ordinarily, if you're suing for monetary relief, for damages or for reinstatement, then you've got to prove that the discrimination was a but-for cause of what you're complaining about, that the decision to terminate you or the decision to use force on you wouldn't have happened except for your race. Not just that race may have been a factor, but it would have to be a decisive enough that what you're complaining about wouldn't have happened to you. That's a higher standard. But in the Age Discrimination Act, it had a standard that talked about, with regard to other things, as opposed to monetary remedies or reinstatement, but maybe internal discipline, freedom from any discrimination. And the court says that's permissible for other remedies. And so we negotiated for that with regard to employee discipline. And so the internal standard would be that any violation of this act on the basis of race or sexual orientation or whatever, that's a violation of the act, and that is a basis for discipline. Obviously, the extent of the discipline is going to vary depending on how serious it was or how racist it may have been. But race cannot be a factor. And the Supreme Court in this bad case said that yes, indeed, the age discrimination did mandate with regard to federal employees that if age played any part in that employment decision, that was a violation of the law. And so that was a key to our negotiating strategy to maintain the existing federal and state remedies that are available through the Iowa Civil Rights Act and through the state or federal courts, but to gain a much stricter, much more basically an unbiased policing standard with regard to police conduct on every aspect of what they do.
In litigation and legislation that you'll see that standard to be applied, whether it played any part, whether it was a motivating factor, whether it was a substantial or significant factor, or whether it was a sole factor. That is one that is negotiated in the negotiations with the city. The city initially insisted upon a substantial motivating factor. We resisted that, said it was unacceptable. And finding the way through Babb versus Wilkie, as Russ has just described, enabled us to move towards a simple motivating factor, which we believe means if it played a part in the decision, it was a motivating factor. But you see how important data collection and transparency are going to be. And of course, they're essential to restoration of community confidence in law enforcement. Right now, there's a black-white inversion. Approximately 2/3 of white people have full confidence in law enforcement to do the right thing. Half to 2/3 of African American and black people do not, and simply has to be the object of all of us to get through that. And that's the notion of community policing, to restore confidence in policing. We all need law enforcement properly following its authority. Go ahead, Ross, with this slide.
Well, I know we're coming close to the end of the hour. I was trying to look at any of the questions that we've got. One question from Alex is, have any other municipalities in Iowa moved towards enacting similar unbiased policing mandates? I think the answer is no, but we think that the Des Moines one will get people's attention. And while we're not going to get time to get into it, we're of course working at the state level, and our hope is that we can get statewide legislation. At the NAACP's pressing, the Governor Reynolds created a criminal justice working group focus committee last November. And that committee had two charges. One was to try to help former offenders with regard to their reentry into society. And the other was recommendations for an unbiased Iowa criminal justice system. And so some progress has been made on the first one with regard to some changes with regard to licensing and so on that are less onerous for persons when they get out of prison. We are working right now with that focus committee for recommendations with regard to an anti-racial profiling and hopefully an unbiased policing statute at the state level. And David and I made, on June 22nd was when the Des Moines City Council enacted the unbiased policing ordinance for Des Moines, and just by chance we were on the docket of the focus committee on 2 days later on the 24th of June, and we made our presentation there that we hope that ordinance would be the catalyst for the state legislation that we hope that they will recommend. And so we are taking and drafting legislation again at the state level that will basically take everything that's in the Des Moines ordinance that's good, and there's a lot that's good, and the areas where Des Moines still has to make further commitments, such as data collection and dealing better with pretextual stops. We've drafted language there and have been in meetings with several of the police chiefs that are on that commission, trying to find common ground, and we are cautiously optimistic that a recommendation will come out of that committee at the Justice and Disparities Conference in late October for legislation this upcoming session. Obviously, elections matter, and the chances for this to happen and to have a more progressive bill, I don't know if it get partisan, but if the Democrats do better, there's a better chance that we would have chances for legislation that would be much along the lines of what we were able to obtain in Des Moines, and hopefully even beyond that.
Let me add, Russ, two quick points. One, the University Heights over by Iowa City did adopt an anti-racial profiling ordinance based on the NAACP's legislation. That ordinance is being considered right now by the city of Coralville for enactment as an ordinance. So we'll keep pressing at this. It's 2 o'clock, and Russ and I are willing. There are a number of questions that we're willing to stay on for another 10 minutes. I think Amy said that was permitted. We understand if any of you needs to leave, and some have been doing so, but maybe we'll take some of these the questions. As Amy indicated, this PowerPoint will be shared on the Drake Racial Justice website. There is, I'm looking at the questions. Do the police departments track demographics of individuals, traffic and pedestrian stops? Well, not generally. In Des Moines, there are internal protocols indicating they should do so with respect to pedestrian stops. That information is very hard to get. Harvey Harrison has gotten some of that. And of course, where a mere warning is given, however much profiling or pretext may have been involved, there's not going to be any filing by any report by an officer whatsoever.
David, can I comment on that?
Yes.
That's one of the huge black holes in the data collection. Is that our proposed legislation has always said, hey, that you are required as an officer, you're required to make file a report, or it can be done right online in the track system with regard to every stop, whether you give a written citation or warning or make an arrest or not. And so even that Monterey Little Jared Clinton, if Jared Clinton's mom had not been sophisticated and knew that there would be a video and that it was available because under the police department's rules, because there was no litigation that came out of that, that would have never have appeared in the stop data, because they didn't give any kind of written warning of any kind, despite holding them for 30 minutes and humiliating the heck out of them and virtually precipitating a provocative situation. That would have been totally under the radar. So our legislation requires officers to report every instance of a stop, and that's critical. And we know that there might be some officers that rogue officer may try to get around that, but then at least if you can find the evidence, that'd be a basis for termination.
The going on with the questions that Iowa Corps asked whether we discuss how the Des Moines ordinance impacts city administration and enforcement. We think that awareness coupled with the data collection is going to guide behavior. that particularly when published, and that data is accessible to the Human Rights Commission, the Iowa Civil Rights Commission, and in litigation, it provides a basis for accountability, which is going to make people think twice. That is one of the objections, I think, that I heard the police chief from the major municipality surrounding Iowa register, that people are going to have to keep all this data, whether it's for a warning, whether it's a bicycle or a pedestrian or a traffic stop, and that data will be individually tracked. They're not going to stop people. There's a fear that there'd be a loss of policing that was necessary. So on how fined or enforced, I think it's always, just as in law, going to depend on the circumstances. I can't imagine how anybody thought that the behavior of Derek Chauvin in Minneapolis with respect to George Floyd was reasonable. 8 minutes and 46 seconds. I don't know how anybody could have thought that police officers looking at that behavior for almost 9 minutes could have thought their failure to intervene was reasonable. I don't know how anybody in Cleveland could think that shooting a 12-year-old boy with a 12 gun 3.5 seconds after arrival was reasonable, but it's a fact issue. Other municipalities are considering our bill, and we're pleased with that. We're going to keep pressing, as Russ said, for adoption at the city level and then at the state level. There's a good question that Patricia Notch, if she's still available, how's the discussion regarding a citizens review board coming along? That was a major issue, and an issue with respect to which our Community Alliance, CCI, and the ACLU of Iowa divided. Actually, NAACP policy strongly favors a citizens review board comprised of citizens not employed by the city nor related to or involved in law enforcement, having full authority and staffing and budget to investigate, preside over, and adjudicate complaints of misconduct. That was a long road ahead, and a lot of opposition. There haven't been many nationally that have succeeded. We opted for the Civil Rights Commission assisting individuals in fleshing out and drafting and filing the complaint with the Iowa Civil Rights Commission, which does have a budget and is charged with investigation. And particularly with that support, a record is being developed that an attorney can access and utilize when the complainant requests a right to sue letter, as under federal and state employment discrimination and other discrimination law is authorized to do. Go ahead, Rusty.
Well, one of the other things that was a beneficial development from the strategy to go to that unbiased policing was this provision in 8645 that obligates both officers and employees of the department to both report unbiased policing or racial profiling, and where a use of force occurs, they have a duty to intervene to prevent or stop the use of that unreasonable force when it's safe and reasonable opportunity exists to do so. So, what we saw with regard to the George Floyd incident, why those officers would have had an obligation to intervene, and to try to stop what was going on there. Likewise, there's protections for those employees who do report biased policing from any retaliation or discrimination for reporting, or for if it turned out they need to testify as to what happened with regard to testifying as well. There was another question about what are the primary objections to anti-discrimination policies? Is it ignorance that racial bias exists, or are there other common arguments? Well, I think that there are those. Certainly, many in the police department world say that it doesn't happen. That it's been barred by internal policies and it just doesn't occur. That's why the data collection is really important to establish that in fact it occurs, and it occurs far too often. And so that's important. One other thing is that to make sure that the reporting mechanisms will be state of the art in terms of something like almost 90% of all tickets that are issued by police officers in Iowa are done on the track system in officers' police cars, and so we want to make sure that they have very easy to fill out forms and drop down menus and that sort of thing to answer, as opposed to having to write out or dictate extensive answers. And so we would certainly work with them and with the department to develop ones that would not be burdensome. We don't envision that it would be significantly burdensome. And indeed, when the Department of Public Safety from Nebraska came and testified at the focus committee, they talked in terms of taking like a minute, maybe less than a minute, to fill out the forms that were required for them.
Well, there's a lot of information in our slides. I know they'll be posted. People who want to get involved can contact Russ or me. Always a place for earnest people in these efforts to strive and reach racial justice in our society. So I'd say farewell. Thank you for joining us.
Thank you very much. Have a great weekend. Be safe. Take care.
Thank you, everyone, for attending. I'll have the link up sometime next week, and we'll send out an email letting everyone know. Thank you.